what she said. She's magical, mystical, a powerful wonder girl.
All right, welcome back to What She Said. We are joined in studio by Soma Ray-Ellis, who is chair of the employment group at Gardner Roberts, LLP, a very prominent law firm in the city of Toronto. And we've asked Soma to come in because we wanted to talk about some of the things that are surrounding Me Too. Let's start, Soma, with what happens if you are the victim of some form of harassment from a colleague. What should you do?
What you should do is gather up as much evidence as you can. So think of it as playing lawyer for a second. What would we need? That's what you're looking for. So you're looking for statements, you're looking for comments, witnesses, anything that, a picture, any video, audio, anything that substantiates your experience.
But in many cases, some of the stories we've heard have been just two people, or it's been in some place like a bar where you're not going to be videoing your whole evening. So isn't it tough sometimes to have that kind of sort of proof?
It's often tough because it often happens on a one-on-one basis. So when you don't have any witnesses and you can't videotape the event because you didn't predict it, you want to document it immediately. So as soon as it happens, you want to go and write down your notes of what happened. You want to tell somebody right away because that becomes the record. Because people's memories fade. So if you put it down on paper right away, if you send somebody an email saying, I just experienced this, or if your friend, you're in a bar and you walk over to your friend and say, you won't believe what just happened to me, that's helpful.
Okay, so then let's take the other side. How should the company react to these allegations that involve two of their employees?
So the companies are supposed to be respectful of both the complainant and the alleged accuser, because everybody's rights count. And that's how it should be. So when a complaint comes to the company, they're supposed to take the complaint seriously. They're supposed to write it down and then assess whether it requires a outside investigator or an inside investigator to investigate it. Now, sometimes the complaint is just an informal one versus a formal one. So somebody says, oh, he just made an inappropriate comment. That doesn't require you to hire an investigator. It just, you can resolve it just between the people. Sometimes if it's very minor, but if it's not, if you've been assaulted, for example, you may need to hire an outside investigator. So they have to make a lot of decisions with respect to process and who is going to be involved in that process. What they should not be doing is making these things public. Just because somebody makes an accusation doesn't mean it actually happened.
Now,
So
when
the
you say
presumption-
when you say that they should not do that, they should not make it. Is it covered anywhere by any employment law under the Employment Act that they should be keeping confidentiality?
So confidentiality, we've always understood it as an act of a civilized society that you would treat these things confidentially. In terms of the law, if you don't treat it confidentially, then you may get sued for defamation, mental distress damages, aggravated damages that results from a bad treatment of a harassment complaint.
So in employment law, as in any other type of law, there is a presumption of innocence.
Absolutely.
Okay, so hypothetically then, if I am corporate communications and I understand that that one employee is alleged to have done something historically to another employee, but the person is at this point unnamed, and I, as the company's spokesperson, release the accused's name to the media, and it wasn't out there before, that's not a good thing to have done.
That's not a good thing to have done legally or just as a corporate governance perspective, because there needs to be an investigation. You need to know the details. You want to make sure the details actually are accurate. Why would you want to harm somebody's reputation, particularly in this day and age, before you do any of that? And even if you find that the person did sexually harass the complainant, companies typically do not release these things. There's nothing really to be gained from a corporate perspective to air out your dirty laundry. So there are many reasons why names should not be released, not just from a defamation perspective, but even from a corporate governance perspective. It is not a good thing to be saying we have harassers in our midst because we haven't properly managed our process, we haven't properly managed our people.
Okay, talking about that process, I think that's interesting because I always understood that in order to be, I know that they can fire you anytime they want to pay you a package and say goodbye. But as far as the suspension process and making that public, don't you have to go through some kind of warning first or be told that this behavior is something you should not do?
So two things. While in Canada you can be terminated, there are circumstances when you can get reinstated. If you're a federally regulated employee, there are strong rules in terms of when you cannot when you can fire them, stronger than the common law or provincially regulated rules. So that's something to keep in mind. The federally regulated, such as broadcasting, is federally regulated. Reinstatement is a real possibility unless the employee's done something really egregious. Secondly, in terms of suspensions, it is sort of the company's duty to educate their employees on their obligations to each other. So companies are required to have human rights policies. They're required to have anti-harassment policies, and they should also have code of conducts. And most large corporations do. But you're required to train your employees, and you're required to make them sign in the dotted line so that they've read it, they understand it, that HR is available to speak to them. So once you get to the suspension, presumably the employee already knew if they did something bad that they would get suspended.
So you have to act like a responsible adult.
You have to act like a responsible adult. Yeah, once the company's done its due diligence. You can't say, they didn't tell me I shouldn't specifically sexually harass somebody, so I think I can get away with it. You're meant to know better. You're meant to know better.
So what about the employee who is making the allegations? If that employee goes public accusing another employee of something, are they also liable then for defamation?
Yeah, I think this is a very important question because of what's happening now. While the Me Too movement is really important, and it's done a lot of good in terms of largely that we're having a discussion about harassment being one of the fundamental experiences.
And the abuse of power.
And the abuse of power, right, that women have experienced since they entered the workforce, that we've tried to legislate, that courts have said that they won't tolerate, and yet we have not been able to eradicate it. So this movement's really significant and important, and it should continue in terms of the discussion between all of us, men and women. But however, if you go and you name somebody in social media, and if it's not true, and if you can't defend yourself when and if they bring a defamation suit, then you're going to get yourself into trouble. So I think we just have to remember that there's two sides to this aspect.
Absolutely. Now, social media must be impacting your business quite a lot.
I'm very busy.
But we all talk about this is not, we talk about due process being a legal term. We talk about this being in the court of public opinion. I mean, it's a very fine line what happens, and it's a very fast line to be crossed.
Well, it's getting crossed very quickly, and as I said, I think the movement's important, but other people's reputations are also important, because how we treat others is how we're going to get treated in the same process, right? So this isn't just going to be a gendered experience, while it has been so far. Women are going to start getting accused of things. So this is not a fight between men and women. This is about a fight between right and wrong. Some things are just wrong. Harassing people, men, women, children, no matter what the color of your skin is, whatever the basis is, that's just wrong. And then if you are harassed, then follow a proper procedure, call people on it, name it, bring it up to the company, or bring a lawsuit. If you're going to do it on social media, then just remember that you may get sued, and so be very sure that everything you're saying is accurate.
Okay, so Soma Ray-Ellis, how do people get in touch with you? What's your company website, Gardner Roberts?
It's grllp.com.
grllp.com.
That's easy.
That's easy. Well, I'm sorry to hear you're so busy.
But thank you so much for joining us.
My pleasure.
This is What She Said on 105.9 The Region. We'll be right back.
Well, she